Very good afternoon, guys. Good afternoon, fellas. Happy Tuesday to you guys. I hope you're all doing great. Today we're going to be chatting about a very, very, very exciting topic. In fact, very exciting. So, guys, join me as we spill the afternoon tea. And we have fun here. All right. So let's start. Guys, drop me a comment when you join in the video. Drop me a comment. Let me know where you're watching from and how everything is going. So today we're going to be talking about, a very tricky subject. Sometimes people will go for interviews and the interviews go so bad. They go for interviews, trying to get green cards or trying to get citizenship. And the interviews go south all the way downhill. Like things go the way they did not expect the things to go. So what do you do in those situations when you don't have an attorney and you didn't think things were going to turn so bad so fast, and then things are just messed up in your face? What do you do? So that's what we're going to be discussing today. So if you file a petition, so for example, you filed a green card application, you're married to a U.S. citizen spouse, and you guys have filed an application to adjust the status of the foreigner, the foreign spouse. And you guys are called for an interview in your field office, and then you go for the interview and it goes really badly. What do you do in those situations? Sometimes the first interview goes very badly, and then you will be maybe called for a second interview to check the validity of the marriage, and then there's a problem. Okay, that's the Stokes marriage or the marriage fraud interview. And so at that point, what do you do when you feel like, okay, maybe we didn't file this application in good faith, or something, there's certain things that we need to straighten out before we try again? What do you do in that situation? So that's what we're going to be discussing. Okay, guys, drop me a comment, drop me an emoji, let me know you guys are here, and let me see where you're watching me from. Okay, so the first thing is that you can do something known as a withdrawal. A withdrawal is a process that exists to help people who have decided suddenly that, you know what, I don't want to do again. Like, I'm the one that submitted my own application, no longer interested. Take me out of your system, USCIS, US Immigration, US government, take me out of your system. I applied, I no longer am interested. Take me out of your system. Do not adjudicate this petition. Okay, do not adjudicate this petition. That's what the withdrawal means. Oh, Isaac Asari says, hey, how are you doing? Hello, Isaac. I'm so excited to have you on here. Guys, drop me your comments. Let me see where you're watching me from and how you guys are doing. So, when an applicant, a green card applicant or a citizenship applicant, somebody who has applied for green card or somebody who has applied for U.S. citizenship, they file an application, and then they decide that they no longer want to have the application adjudicated, because the reason why you sometimes need to do this is that when a decision is rendered on your application, sometimes it will have very crazy consequences for you, the applicant, or you could be in very big trouble once the application is adjudicated. Okay, so when we say the application is adjudicated, it means that a decision is rendered based on the merits of the application, and that would have some very serious consequences on your life here in the US. Okay, you could be arrested, you could be, of course, deported, or you could be barred from certain privileges and all of that. So those are some of the very, very crazy consequences of filing an application that will go all the way down, like so fast. So first of all, as we said, you need to file what's known as a withdrawal. And you need to make sure that even before you arrive at the decision of filing a withdrawal, you need to speak with a U.S. licensed immigration attorney, somebody who actually focuses their practice on U.S. immigration, to review, the strengths and the weaknesses of your case and to make a legal assessment. This is not something you sit in your bedroom to determine that, oh yes, I want to file a withdrawal, and then go ahead and then get yourself into, a bigger mess. So you need to make sure you are speaking with the person you should be speaking with to make a correct judgment as to whether or not you need to withdraw your application. Okay, and of course, there's also, we'll get to what a timely withdrawal or a timely retraction is. So the first thing is that a petitioner, at what point can a petitioner withdraw their U.S. immigration application? If you're filing a type of visa, or you're filing, any type of application, any type of U.S. immigration application, you may withdraw your petition at any time up until the point where a decision is rendered by the United States Citizenship and Immigration Services, USCIS. Okay, so you cannot now withdraw your petition after a decision has been rendered. Okay, so if you file an application, a marriage-based application, and then a decision is given, like it's denied, you cannot, subsequent to the denial, now file a withdrawal of that application. It's too late. It needs to be filed timely. It needs to be timeous. Okay, so all these are very time-sensitive applications that you need to do at the right time in order for it to have the right legal effect that you want it to have. So the first thing is that you need to file the withdrawal before a decision is rendered by the USCIS, or when it's a petition that is approved until the beneficiary has actually been admitted, or has adjusted their status, or has also changed their status based on that approved petition. So these are 2 time frames, okay? These are 2 time frames, either before a decision is rendered or before the beneficiary has actually adjusted or changed their status or been admitted based on that approved petition, if the petition is approved. Before that, those are the times when you can actually file a valid withdrawal, or a withdrawal that will have effect, that will have the right effect or the right consequence for your case. And guys, this is something that you people have to note. A withdrawal cannot be retracted. You cannot retract a withdrawal. So you cannot file a withdrawal and they say, oh, I retract, and then file, and no, nothing of the sort. So I've had people who have filed for their husbands or their wives or their boyfriends or their girlfriends that they are madly in love with, or they want to spend their lives together, and then they have a big fight, and the U.S. citizen or the green card holder spouse decides that, look, I'm going to withdraw the application. I'm no longer filing for you. And then they call USCIS or whatever. They do something that will jeopardize the application. So I've actually had cases like that where clients, so one client was a U.S. citizen. He's based, of course, here in the U.S., and he filed for his wife, who's based somewhere in Africa. In fact, I've had a number of cases like this. And then they had a big fight. And you guys know how backlogged USCIS can be. Like, once your application is in the system and they start processing, they send it to the NVC. Sometimes it takes a while. And then the U.S. citizen spouse of course, they had a fight, and, a romantic fight. And then the U.S. citizen spouse got angry and then called the USCIS and said they were canceling, or emailed and canceled the application, said, look, I'm the U.S. citizen's spouse. I said I no longer want my wife here. I've canceled it. I've canceled the application. So, after a few days, they got back together, lovey-dovey, they were happy. And then the guy had forgotten that in his anger, he had called and canceled whatever. So the wife went to the embassy or the consulate in her country, and the time had come for them to take the visa. Everything had checked off. Unfortunately, she was denied. On what basis? Well, your husband actually canceled the application. She had waited for so many years. The guy was devastated because it was a very minor lovey-dovey romantic fight. and they actually had children together, and he was looking forward to seeing the children come, be here, reunited, the whole family reunited. And because of his anger, he withdrew the application, and all the years that they had waited down the drain, washed down the drain. I don't even remember whether it was about 4 years or 3 years or whatever, down the drain. And they now had to start the whole application again. Guys, the legal principle remains: a withdrawal may not be retracted. You cannot in your anger file a withdrawal or issue a withdrawal, and then you guys make up, you guys are no longer fighting, and then you come back and say that, oh, I now want to retract my withdrawal. Doesn't work that way. File application, withdraw, no retraction can be valid from that point. Okay, so guys, be careful. So that's why normally for people that are my clients, if there's any type of fight and they come and see me that, let's say I want to withdraw the application, I know what I take them through because I've seen it happen a number of times. And so there's something we take them through, and, of course it's a legal process, and with a law firm, we don't suddenly file a withdrawal. It goes through the process, and usually very, 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 very often, by the time we finish going through the process, they've calmed down and they're like, you know what, lawyer, I don't want to withdraw the application for my wife, or I don't want to withdraw the application for my boyfriend. It was just a fight. I'm over it now. So they're like, oh my God, I'm so thankful that I came to see you. So guys, a withdrawal may not be retracted. You cannot file an application, withdraw, and then try to retract a withdrawal. They don't have time for you. Like, they have hundreds of thousands of applications to adjudicate. So you can't be playing ping pong with them. Like, okay, so now let's go to, guys, let me drop me a comment to let me know if you guys can hear me. Let me read a couple of comments and then we continue. Oh, Johnny Richard Nelson says, powerful. Thank you so much. My condolences to you during this hard time. Johnny, please accept it. Frank Darko Genfi says, when you file a marriage-based green card after submission, how long does it take to hear from them? That depends. Whether the person, the petitioner, is a U.S. citizen or he's a green card holder. Also, it depends on whether the beneficiary of the application is here in the U.S. That would be an adjustment process, or he's out of the U.S. That would be a consular process. So all of that depends. Johnny says, push it. Thank you so much. He says, you're looking stunning. Thank you so much. Oh my goodness. I went to conduct some business at Chase Bank today. Some business, some requirements, and I went there today, and unfortunately these people refused to cater to me because I hadn't pre-booked my appointment, so I need to go back there soon. So that's why I am all glammed up today. Okay, guys, so let's continue. Once a petition is withdrawn, what is the legal consequence? So once you've withdrawn, so you filed a valid petition, it's been properly receipted, and then you file a withdrawal, a proper withdrawal. And a proper withdrawal means that you have actually had a U.S. licensed attorney who has looked at the merits of your case and has actually advised you to withdraw. Because sometimes you may go file a withdrawal and that will be your doing or your undoing. So you want to be careful with that. Make sure your withdrawal is well justified and has a basis both in fact and in law. So once a petition is withdrawn, what is the legal consequence? The legal consequence is that USCIS, that's the United States Citizenship and Immigration Services, they may not refuse the withdrawal. So you can't file a petition and then you say, you know what, I'm not filing anymore for my wife, and USCIS will say, US government will say, no, we refuse to accept this withdrawal. No, they cannot do that. So these are cases I'm reading from. So Matter of Cintron is one of the cases for withdrawal of petitions, Matter of Cintron, and a few others. Let's focus on this. So they cannot, it's just like saying that you've proposed to your girlfriend. You are the one that proposed, and you can at any time withdraw that that proposal, right? So let's say the USCIS is your girlfriend. Once you've submitted your withdrawal to her, your girlfriend can say, no, I'm refusing this withdrawal. As for this proposal, yes, I'm ready to get married. You cannot withdraw your proposal because it's not up to her to decide whether or not she can refuse the withdrawal. You are the petitioner, and once you've decided that, look, I want to withdraw the marriage-based petition for my wife, USCIS has no choice but to allow and accept your withdrawal of the petition. It's up to you. Nobody else can decide that they don't want you to withdraw. So USCIS cannot refuse. The language and case law says it may not refuse the withdrawal. And then the next thing also is that USCIS may not also deny the petition based on the merit. So once you have withdrawn a petition, they cannot deny the petition based on the merit. So if you propose to your girlfriend, you're like, oh, look, I love you so much, I want to date you. And then you've withdrawn it. Your girlfriend cannot now come back and say that the girl, well, your prospective girlfriend, because she's not yet your girlfriend, she cannot come back and now say that, oh, no, I actually don't want to date you. You've withdrawn your proposal. So there's nothing to approve or to deny. That's the whole point. So once you've withdrawn your petition, there's really nothing USCIS can adjudicate. They cannot deny the petition on the merits of the case, okay? But there's one thing to note. You have to note that the facts and circumstances, my phone blowing up as usual. Let me put this off. Sorry for that. So once you've withdrawn the application, the facts and circumstances surrounding the withdrawn petition will be considered material to any new petition. Matter of Cintron. What does this mean? So if, for example, you filed a marriage-based green card again, and you guys went for an interview and it went downhill or went all the way south, like it went crazy, and it was, let's say, a sham marriage, a marriage just conducted, or a transactional marriage, a marriage just entered into for the purposes of a green card. And then they start asking you guys questions and you realize that, like we've been busted. At that point, a decision has not been given. So you may, of course, depending on the type of questions or what happened or transpired at the interview, you may consider withdrawing your application. You may withdraw it, fine, before a decision is rendered. However, the facts and circumstances, the fact that it was maybe they discovered that it was a sham marriage, there were certain facts or circumstances. They realized that, you guys claim you live in the same house, but you don't even know how many bedrooms are in the house or how much the mortgage is a month, things like that, for example. They will consider those facts and circumstances surrounding the withdrawn petition. So if you file any new petition, let's say 2 years down the line, you file a new petition, you've now met, your handsome man, and you guys are in a genuine marriage. The facts and circumstances of the withdrawn petition will be considered material to any new petition that you file subsequently. Okay, guys, I think that at this point, we can end here. Let me take a note of where we have gotten to have a timely and voluntary retraction. So we'll talk about timely and voluntary retraction, what it's good for, and the legal consequences and all of that of those types of withdrawals and retractions in our next video, hopefully. Okay, guys, so if you need my help, don't hesitate to call me 802-7800-564, and I will be happy to assist you guys. Okay, Ruth Amanyamiche says, well done, sis. Thank you so much, Ruth. Frank Daku says she's a U.S. citizen and her spouse is also in the U.S. It depends. Frank, it depends. It just really depends. You guys give me a call on 802 and then I can look at your case and assist you and answer your questions into detail. Okay, there's no one size fits all. One of the most popular answers in law school is it depends. A lawyer will always tell you it depends. There's really no like one blanket rule. There are like 1,000,001 exceptions, and sometimes there are exceptions to those exceptions, and there'll be rules to those exceptions and categories within those exceptions. So it just really depends on so many things. So please contact me and I'll be happy to assist you. All right, guys, I wish you guys a wonderful rest of your day. Be safe, be good, and I'll see you in the next video. Bye.